Hi everyone, my name is Crystal Lilo, and today I'll be presenting on different forms of legal competence from our Milton readings and related cases. Competence is one of the cornerstones of forensic psychology because it determines how fairly someone can be involved in the legal process. Over the next few slides, I'll walk through the different types of competence, the standards the standard courts use, and why they matter. Let's start with competence to consent to search and seizure. Consent to search and seizure. When we think of searches and seizures, the Fourth Amendment comes to mind. But the real question here is, does a person actually understand what it means to give consent? Competence in this context is about recognizing that if you allow the police to search your home or car, whatever they find can be used against you. Forensic evaluators look at whether the person truly grasps the consequences of saying yes. For example, someone who consents without realizing they're waived a constitutional protection may not actually be competent to provide that consent. Right to remain silent. We all know the Miranda warning. You have the right to remain silent, but competence here goes deeper. It's not enough for someone to hear the words. They have to understand what the right means and what could happen if they give it up. If a suspect talks to police without grasping that their words can hold that their words can be used in court, then the waiver of the right isn't meaningful. This is where forensic psychology step in. We assess whether the person really appreciates the importance of remaining silent and the risk of giving that up. Plead guilty. Pleading guilty is one of the biggest decisions a defendant can make because it essentially waives the right to a trial. Competence in this area means the defendant understands exactly what rights they're giving up and what sentence they could be facing. For example, when someone pleads guilty, they can't later change their mind and demand a trial. So it's important to confirm that the decision is informed, voluntary, and made with a full grasp of the consequence. Waive counsel of self-representation. This brings us to the Beretta versus California case, where the court rules that people can represent themselves in court if they're competent to do so. But here's the important part. Competence is about the decision to waive a lawyer, not about being skilled enough to argue like one. Representing yourself is very risky. Most defendants don't know the rules of evidence or courtroom procedure. So evaluators look at whether the person understands what they're giving up and the dangers of self-representation, even if they still choose to go forward with it. Refuse insanity defense. This area is especially complex because it raises questions about anatomy versus fairness. Should someone be allowed to refuse an insanity defense, even if it could spare them from the harshness punishment? Competence here is about whether the person fully understands the consequence of rejecting that defense. A well-known example of Dylan Roof, who refused a mental illness defense because he didn't want the stigma, even though it could have saved his life. In cases like this, we ask, does the defendant understand what they're giving up, or are they too impaired to make that choice? Testify. For testimony, the focus is on whether the witness can recall events, communicate them, and understand the obligation to tell the truth. The standard doesn't require perfection if even children or vulnerable adults can testify if they meet this criteria. For example, a child who can describe what they saw in their own words may be considered competent, as long as they understand the difference between truth and lies. The key question is whether the testimony can meaningfully contribute to the proceedings. Execution of and appeals. Here, we're looking at the most serious outcome in the legal system, execution. In Ford versus Wainwright, the court ruled that someone can be in Ford v. Wainwright, the court ruled that someone can not be executed if they don't understand the reason of their punishment. Competence in this setting means the person must grasp the connection between their crime and the crime and the consequence of death. Appeals raise the smaller issues. Can someone knowingly choose to give up their right to appeal? These are not just legal questions, but ethical ones, especially when severe mental illness is involved. Guardianship. Guardianship comes up in civil law, but it still involves questions of competence. The standard here is whether a person can handle the basic decision of daily life, things like managing finances, medical care, or living arrangements. For example, an elderly person with dementia who can no longer manage money might need a guardian to step in. The goal isn't to strip people of independence unnecessarily, but to make sure vulnerable individuals are protected when they can't make safe decisions for themselves. Treatment decisions. This type of competence ties directly to informed consent. A person has to understand the risks, benefits, and alternatives of medical treatment. It's not enough for them to just say yes or no. They need to be able to reason through the decision. For instance, agreeing to a surgery without understanding the possible complications wouldn't count as a competence consent. Evaluators look at whether the individual can weigh the pros and the cons and make a choice that reflects their understanding. Consent to research. Consent to research is very similar to treatment, but it has its own standards. There are 4 key elements here: understanding, appreciation, reasoning, and choice. Participants must know what the study involves, the potential risk and benefits, and that they have the right to withdraw at any time. Safeguards are especially important when working with vulnerable groups like children or people with mental illness. The focus is always on ensuring that consent is informed, voluntary, and ethical. Testamentary capacity. Finally, testamentary capacity refers to someone's ability to make a valid will. To meet this standard, the person must understand what property they own, who their hearers are, and how they assess will be distributed. For example, if someone with advanced dementia no longer comprehends these things, their will may not be valid. The evaluator's role is to determine whether at the time of writing the will, the person had enough understanding to make meaningful decisions about their estate. To wrap up, competence isn't a single standard that applies everywhere. Each legal content, from pleading guilty to testifying to making medical decisions, has its own rules and challenges. As forensic psychologists, our job is to make sure people understand their rights and choices so the legal system stays fair. Competence is about protecting both the individual and the integrity of the court process. Thank you.